Welcome to Illuminating Hope, a podcast of Hope House. In this series, Advocating Justice, the Legal Battle, we dive into the legal battles that shape the fight for domestic violence survivors. In each episode, we bring you powerful conversations with the legal teams, court advocates, and change makers working tirelessly to bring justice, protection, and hope to survivors of domestic violence. From the courthouse to policy changes, from survivors' rights to legal strategies, we uncover the critical role the justice system plays in breaking cycles of abuse. Whether you are a survivor, advocate, or someone passionate about justice, this podcast series will empower and inform you. Justice isn't just about the law. It's about giving survivors a voice, protection, and a future. Nancy Putman is a seasoned attorney with extensive experience in family law, civil litigation, and criminal prosecution. She has been practicing law in Missouri and Kansas since 1989 and currently serves as an attorney at the law offices of Nancy K. Putnam in Prairie Village, Kansas, where she specializes in family court and civil litigation. Since 2011, Nancy has also worked as a contract attorney for Hope House, providing legal representation to survivors of domestic violence in protective order hearings, child custody disputes, divorces, and other civil matters. She actively collaborates with law professors, community partners, and legal professionals to enhance domestic violence advocacy and education. Additionally, she mentors law students, coordinates pro bono legal services, and serves on multiple domestic violence coordinating committees in Jackson County, Missouri. Nancy's legal career includes roles as an assistant prosecuting attorney in both Jackson County, Missouri, and Sedgwick County, Kansas, where she handles high-profile cases involving sex offenders, child abuse, and domestic violence. She has also served as a special prosecuting attorney. Throughout her career, Nancy has been a dedicated advocate for victims, a respected legal educator, and a leader in policy development surrounding domestic violence and child protection laws. Nancy, welcome to the Illuminating Hope podcast. We're glad you're here.
Sure, thanks for having me.
I would love for you to tell our listeners, first of all, explain your job and what you do and how you partner with Hope House.
I am an attorney and I have a contract with Hope House to represent Hope House clients and other agencies that Hope House has a partnership with. I represent those clients in order of protection cases, both for an adult or if there's a child order of protection attached with that. I represent them in domestic cases, which are divorces and paternity cases, child custody, and sometimes I help them with landlord-tenant issues as well.
Why do you feel it's important for victims to have lawyers that understand specifically domestic violence?
In a divorce, for example, there is power structure. Really, in all of those cases, there's a power structure. And if someone isn't aware of that, when you look at something on face value, it might not appear that one person hasn't had the equal power in the relationship, hasn't been able to make financial decisions, hasn't been able to make decisions about their body, about their jobs, about their families and friends, all those kind of things. So I think having an understanding of domestic violence helps me to represent my clients more adequately in court, helps me to explain to the judge, be an advocate for my client with the court or with the guardian ad litem to try to really get my client's position across.
I'm curious about that piece. So we know domestic violence is about power and control. What's your approach like with the offender? We'll call him the offender, but the spouse's attorney. Do you find yourself having to do a lot of explaining, or do you get into conversations with them about their client's behavior and what they're asking for?
Definitely. Hopefully my client has an order of protection, so that's already court ruling that backs up my client's position admission that she has been a victim of domestic violence. So that's a great starting point for me if that in fact is the case. But it isn't always, because sometimes my clients don't go to the police out of fear and a million reasons, really, or they don't get the order of protection. They didn't do it, they didn't follow through, they weren't able to, they didn't know about it. There's a lot of reasons why that didn't happen too. If I do have an order of protection, if my client does, then that's definitely a great starting base. I talk about the behavior anyway, either way, because those are evidentiary issues that I can present to the court. So that's also something that I'll negotiate with the other attorney about. And it's kind of funny. Sometimes the other attorney acknowledges it and kind of says, we know that, and can we move forward from there, because maybe they're trying to get a divorce or something like that. And sometimes the other attorneys just completely blow it off and act like, well, it doesn't even exist. Doesn't matter. It's irrelevant. And so then the conversations get maybe a little bit more heated.
I can imagine with this conversation.
I can imagine.
You're being so calm about it over there. I'm like, sure, would be nice to be a fly on the wall to hear those conversations.
Why do you think it's important then for the judge, for the GALs to understand that domestic violence component as well?
Well, first of all, sometimes it's almost a feat for my clients to even get into court, for them to literally physically get their body into court, especially if the other side's going to be there and they've had this relationship with this person. It's terrifying. I had court this morning and my client was so anxious, and she just kept saying, I know he's going to come and he makes me so anxious. He makes me so anxious. And I kept saying, I think he will come, but we're here, we're seated. I'll do the talking. You don't even have to talk. Don't even look at him. And so just getting into court is sometimes the first step and an accomplishment for my clients. So I want the court to know that my clients putting themselves there, maybe testifying, is very difficult. And sometimes when they speak, it's hard for them to convey what's going on. And maybe the other side's in the court and they're trying to give them kind of the snake eye. Or they're just using their body, even sitting, using their body to kind of command the courtroom or to give a signal to the other side that my client's picking up on, but maybe nobody else is. I am, because I'm watching my client freak out next to me, but maybe the judge isn't aware of that. So I think it's really important to kind of keep the courts aware and apprised of what's going on. And here's another example. Sometimes, for example, a client will say, well, he threatened me. And I'm saying my client is a female because the majority of my clients are females, but I definitely represent men. But the majority of my clients are females and the majority of their abusers are men. So just in a generic conversation, I would say she might say, well, he threatened me by saying that he'll report me. Maybe I have a status, an immigration status issue. He's going to report me. Or he'll threaten me by saying, I'm going to harm your family, or I'm going to harm your kids, or other things like that. So maybe not necessarily even a direct physical threat to my client, but to people that she loves. Okay, so when I tell the court, well, he threatens, her immigration status, I want the judge to understand how significant that is and how scary that is for someone and how totally belittling and demeaning that is for that person, and how that then their power dynamic completely shifts. So if he says, I'm going to threaten that, then she's going to probably do what he says, even if she doesn't really agree with it, because she's hoping that he won't provide that information to authorities or something like that. So I need the court to understand background of what's going on. And sometimes the threats are much more benign, but if the judge doesn't know, let's say my client says, well, he doesn't like how I prepare dinner. And so if I don't prepare a meal he likes and he's mad, he's angry, and then I know later in the evening he's going to insult me, or he might even physically harm me. He might take away my phone to punish me, so to speak. So if he would complain, oh, I don't care for this dinner tonight, that doesn't sound like that big of a deal, right? But it is in their relationship, because that is the start for what's going to happen next, which is not going to be pleasant for my client.
We were talking with another podcast where that example came up and how difficult it can be to convey that to someone else, but how that person knows what's going to come next. The examples that she was giving were, he didn't say anything. Right. He just gave a look. And no one around really, they didn't know what that meant. But for that particular client, it was terrifying because she knew what was behind that, where everyone else was like, what? And so then she comes across looking like she's making things up or she's hysterical hysterical or she's over exaggerating.
She's overreacting.
Right.
She's too emotional.
Right. She's nitpicking.
Yes.
Right.
Yeah,
But really, it's about understanding how those threats have been carried out in the past and being able, I think, as you as her attorney or you're her advocate in that moment, being able to help her to be able to share the significance of what that means for her.
Exactly. And before my clients testify, we talk about those kind of things. And I have to respect their ability to convey that information. And sometimes they'll say, I just can't go there. I can't talk about that. And so I'm not going to ask about that because that's just going to upset them. And then they might look a little irrational in front of the court. Plus, then some of the evidence I really do need to get out, she maybe have shut down now. And so now I'm not going to be able to be a very good advocate on her behalf. So I kind of have to know some of the things that client is willing to even put themselves through at that particular moment for court and sometimes what their boundaries are. And sometimes no one's respected their boundaries. So I'm going to respect their boundaries. Sometimes it would have been maybe great evidence, but if she can't do it, I'm not going to force it because it's not going to help anyway. And plus, it's going to affect our relationship of trust.
I think that's just what's so important is that, as you said, nobody's respected her boundaries previously, but for you to do that will take that trust that much further for her, that she knows that she can count on you, even though it may seem like it's not benefiting her or helping her.
Right.
Sometimes it navigates itself in a negative direction. So maybe your client has this idea of what needs to be said to the court, and you know the law and this is your job, and that might not be something that be looked at in the best interest for the client. So how do you navigate that type of reaction that comes from clients where they want this out, but you don't know if that's the right way to go about that?
That's a great question. So hopefully we have a strong relationship by the time something's going to be presented in court, because I've spent time now with my client preparing documents and talking to her about the case and just preparing. So I'm very direct. And so I will tell them, my client, listen, this isn't really persuasive evidence. This is going to take us down a sidetrack. It's not admissible evidence, perhaps. We want the judge to stay focused on these really important issues, so we don't want to sidetrack on that. The other side will object, and then that kind of sets you back a little bit. So you're just going to have to rely on me that I'm not going to bring it up. Now, at the end of their testimony, typically I try to say to my clients quietly, is there anything else you wanted to say? Did I miss anything? And sometimes you'll say, well, I want to say such and such. And I'll say, we've already discussed that. I'm not going to ask you about that. They're not always so happy about it, but either they trust in my legal expertise and advice or they don't. And I mean, I've had a few that have probably not been super happy about it, but hopefully the judgment came out and then they were happy. I have to also follow the law.
You had brought up orders of protection or ex partes. First of all, is there a difference between that or is it just language? And secondly, how long can you get an ex parte or order of protection granted for?
They're definitely different. So an ex parte is a ruling by a court without the other side having an opportunity to be present and heard and have due process. It is a decision by a judge based upon a verified petition. So our client has written on a petition, signed it saying that it's true and accurate to the best of her ability. And in there are the allegations as to why she needs an order of protection. Why is she afraid for her safety? What specifically has this other person done? Has he stalked her? If so, when and how? And it has to be, on stalking, has to be more than one occasion. Has he physically harmed her? Has he threatened her? Has he abused her financially or sexually? Has he abused a family pet? Has he made these kind of threats? And it has to be persuasive enough in written language for the judge to decide, yes, I will give you an ex parte. With that ex parte order, the judge can allow client to reside at a residence and require that the other party have to leave. The judge can mainly say that the other party, the abuser, that person's called the respondent cannot have contact with the petitioner, the client that's asking for the order of protection. But the court has to actually review that decision in a pretty quickly time frame. So the other side, the respondent, has to be served with that order of protection, because up until this point, that person doesn't even know about it. The petitioner has just gone to the court directly, essentially, through the clerk's office. That person has to be served with it, the respondent has to be served with it, and then that respondent has an opportunity to have a hearing. And so does my client. The petitioner has the opportunity to have a hearing too. because now she needs to testify about those things that she put in the petition and why that makes her afraid for her safety and why she needs an order of protection. And maybe she has other evidence. Maybe she has photographs of injuries or videos, ring camera videos, or maybe a neighbor interceded in an altercation and that neighbor is willing to come testify. My client has opportunity to put on testimony, her testimony, witnesses if they're available, and the other side does too. And then the court, after that hearing, will decide if someone gets a full order of protection. So it's no longer an ex parte, now it's a full order of protection. Those full orders can last 180 days to 1 year with an automatic renewal for a second year if the court thinks it's serious enough it might take 2 years. And I'll tell you, one thing the courts a lot of times will look at on that is, for example, the judge might ask me, is there a divorce pending or is there a paternity case pending? And if in fact there is, and I can say to the judge, Your Honor, I don't think that the divorce will be finished up within a year. My client really needs it to last longer than a year because we need to get the divorce finalized before the order of protection expires. Now, if during the hearing, I can elicit testimony that the court makes a finding that the respondent is a serious danger to my client's physical or mental health, then I can ask the court for the order to last 2 to 10 years. Those hearings are more complicated. My client has to be able to testify, and I really have to have a significant amount of abuse to get that kind of extended order. That 2 to 10 year actually is a fairly recent change in the statute. I'm still in the process of educating and persuading judges that sometimes that's really appropriate. I had a case where I did receive a 10-year order, but she had a lot of testimony expanding over a marital relationship of about 15 years. And it was a lot of really abusive behavior that she had suffered. And she did receive a 10-year order. And then on the 2 to 10-year order, it's about to expire, but that client still needs that order of protection for whatever reason, she can go back again and ask it to be renewed. And it actually can be renewed for a life. I have never had a renewal for life because, for example, I just said that is a fairly recent change in the law. So, for example, that client that got the 10-year order, she isn't even eligible to ask for that for probably 7 years. That was probably 3 years. So it hasn't even really come up yet, at least none of my clients.
It's interesting to talk about that. I was doing an interview this morning and I get asked this a lot, but they said, talk about protection orders and do you recommend them and do they work? So I know how I answered that. I'm curious what your answer to that would be.
Oh my gosh, I 100% recommend order of protection. Rarely do I not think a client should at least try for one. But I will say that if you go to trial on order of protection and the petitioner who's asking for one loses and does not get the order, that definitely is a power issue because now the offender, the respondent, thinks, oh, no one cares. The police don't care. The judge isn't going to do anything about it. And sometimes I'm afraid that that's like an invitation to that person that, well, now I can do anything that I want because no one's going to stop me. So if it's not a strong evidentiary case, I really have conversations with my client. Do you want to go forward? And I'll represent you. If you want to go forward and what you're telling me is truthful and you feel like you need no protection, I will represent you. But you have to know that this is the risk. And this is your case. This is your life. And then you make that decision. And it's not just a piece of paper though, because like I was saying, I can use that evidence in a divorce case. It can be part of determination on child custody. I think law enforcement probably will take it more seriously when she says he's back at the house and I have an order of protection and this is a violation. Please come get him. You know, he's scaring us. He's scaring my family. He's scaring me. It just documents it. It's a judicial ruling on someone's behavior. It's a finding, and I think it's persuasive.
So what do you think the difference is between a divorce that has domestic violence in it and a divorce that doesn't have DV? We know there's a power and control dynamic, but do you have anything else to add to that?
Well, there can be a power and control dynamic even without domestic violence.
You're right.
For sure. Finances are often, money is power. I mean, just let's be honest. So if one person makes the majority of the income and the other person doesn't, there is an inequity in power right there.
Right.
I have a private practice, and in my private practice, some of my clients don't have domestic violence issues. They just are ready for the marriage to end. And marriage is a legal entity. It's a contract, and there are a lot of financial ramifications as well. I think the difference is that with a divorce, it has domestic violence piece, especially if there are children involved. Most of my clients would say that child custody part of the divorce is so much more important than the financial part. They need to be able to survive and eat and feed their children and so forth. But if their children are safe and what's going to happen with the kids usually is top priority for my clients.
And we did learn in the podcast that we just had with one of our therapists too, when we talked about the power and control wheel. Often in the court process, children can be used as a pawn. Have you experienced that? I'm sure you have experienced that. Yes. And can you talk about it a little bit?
Definitely. The court looks at 8 factors when the judge is to decide what's in the best interest of the child. And if a guardian ad litem is appointed, and that's an attorney that represents the children, that guardian ad litem looks at those factors as well. And when I'm arguing a case as an advocate on behalf of my client, I argue those factors as well. And one specific factor actually mentions domestic violence because again, that's fear in the home, that's safety in the home. Sometimes a respondent will say, I'm not admitting that I did anything to my wife, but I for sure did nothing to my children. It is so naive to think that those kids do not know what's going on in the home. Toddlers can feel the anxiety and tension in the home. You know, the children hear the yelling in the other room. They can see how one parent changes when the other parent gets in the room. That parent's nervous, that parent's scared, that parent's walking on eggshells. When the other side, when the respondent says, well, I didn't do anything to the kids, or I'm a really great dad, those kids love their father. And if that person can be a good father, usually my clients will say, I want my kids to have a relationship with their father, as long as he's safe. They can be used as a pawn, but I think those factors that the court looks at helps to pull away from that a little bit. Gives us some factors and some legal standing to maybe not let that happen.
You partner with Hope House, you contract with Hope House. Do you see a difference in victim success rates if they have a part of the Hope House wraparound services that are helping them?
Completely. I mentioned a client today that was very anxious, and I met with another potential client today, and she was sad and weeping and so forth. And I just kind of stopped what we were talking about. I said, are you in therapy? And she's like, no, I can't afford therapy. And I said, well, let me tell you about Hope House, and let me tell you about therapy, and I'm going to ask my paralegal to get you a referral, and you need this. You need therapy for your own self to heal, and you're going through a really tough time. This was a order protection client. You're going through a hard thing. You have to go to court, and you have to face your abuser, and at some point you're seeking a divorce, and that is a very drawn out process, and you need to get some therapy if you're willing, if you're open to it. And let me tell you what Hope House can do for you on that. I have that conversation once a week probably with clients, and it's amazing how they'll say, well, I'm on waiting list and I can't get in, or I can't afford it, or he had the insurance and now he's trying to block me and so I can't get therapy, or I'm afraid to get therapy because I don't want him to see it on the insurance that I'm getting that. And there's so many obstacles. So if Hope House can have a case manager that will maybe help with relocation and help with therapy and maybe help with if the person trying to look for a job and needs daycare or is staying in shelter and their kids need daycare while she's out interviewing. There's so many things that Hope House can do that just helps the whole person. And I'm just one piece. They've got a lot of other issues, and why not get the support you can get?
We actually have therapy groups for people who are going through family court or the child custody court that are Zoom, and anyone can jump on those. They would just have to call our hotline for that information. It's a great opportunity for someone who maybe is on that waiting list for therapy with us.
Yeah. And sometimes it's just good to know that you're not the only one in that boat. So like that group therapy, it's probably helpful.
Well, oftentimes I think that people think therapy is negative, and also that is something you're crazy, and that's what's been told to our victims over and over, and that if they would go and get that type of service, they feel like maybe that could be used against them as well.
Or they're weak. Right. You're weak if you have to go to therapy. I don't see that used against them a lot. I'm not saying that the abuser hasn't threatened that and told my clients that, but once they get into therapy and they start getting some benefit from it and maybe getting a little bit stronger, most of them really, and if they can get a nice connection with your therapist, and that doesn't always happen on the first time. And I've told clients that, okay, so maybe this one wasn't the right connection for you, but don't give up on therapy. Give it another try. Maybe somebody else you'll connect with better. I think sometimes clients are very concerned their therapy records are going to be admitted into evidence against them, and then there's going going to be some diagnosis and so forth. And really, most of the courts, and I have actually seen this change over doing this for Hope House for 14 years, but doing family law for probably almost 20. The courts are more educated on that. I think society is more educated on therapy, especially after COVID. There are so many people that were very upfront about how they suffered during COVID and had to get therapy and really had a benefit from it, that I think some of the stigma is lessening. But my clients don't necessarily know that if they've been beaten over the head with that information. So once they get going, most of them weren't all that concerned about it.
I think it's important too to recognize that our therapists are trained in, obviously they're trained therapists, but they also understand domestic violence. So they really can help them to navigate what's going on with them. And we've always said therapy is not about somebody being crazy, which is what I think it used to be, the stereotype that you were crazy. And if you went, then that meant you were, you needed to be committed. It's really about offering them the support and helping them navigate through the trauma that they've experienced.
Exactly.
And someone who's trained in that and someone who specializes in that can really help someone in that process. And we don't charge. That's the other piece of that we can help with that piece. It's not going to go through your insurance company. It's not going to go back to that person unless you want them to know that.
Exactly. And I know that therapists spend time explaining confidentiality. And I think that probably, gives some comfort to the clients that are getting therapy. That being said, though, I have had therapists testify. Now, my clients always agree to it and they've consented to it and so forth. But I've had therapists testify quite a bit, maybe in reference to our children or in reference to my client when we thought it'd be beneficial. And the therapists that have testified, either Hope House therapists or therapists just in the community, they can be great witnesses. They can be great advocates for the clients.
We talked about the stigma surrounding mental health and how that's changed, which is such a positive. What else do you think has changed through the years of doing family law?
Well, I think that people do acknowledge that there's more domestic violence going on. I think that if it didn't affect you or your immediate friends, or they didn't tell you that it affected them, I think people didn't think it was as pervasive as it is. This is kind of a strange anecdote, but I was thinking about it today. I don't know if anyone saw this, but there was a show on Netflix, and it was during COVID, and it was called Maid or Maids.
I watched the whole series, yes,
Okay.
and it was the most true to topic I think I've ever seen on the screen.
I couldn't get through it because it was just too close to my work life. And I watch Netflix for entertainment, and domestic violence isn't entertaining to me.
That's right.
But I can see how it would have been very beneficial for someone to see it because it is eye-opening. And I did start to watch it. And actually, I think it was the first or second episode. And the abuser, he threw a glass on the wall, and the victim, his paramour, was by the wall and it shattered. At the same time, I had a case pending where the abuser threw a glass in a vehicle, inside a vehicle, and it hit the back windshield, and glass fell on their child. And I was like, this is someone who's really experienced domestic violence is helping with this script. I couldn't watch the show anymore because I was dealing with that case, and my client was talking about picking glass shards out of her baby's hair, and I thought, oh my. Stuff like that, though, I do think can be very eye-opening. I think that people are more aware that it's a real factor in some people's lives.
Well, we certainly talk about it a lot more than we ever used to. And I know that the Nicole Brown Simpson case was one of the things that helped to bring it out into the open and helped to really shed light that it can happen to anyone. It can happen to rich and famous, and it can happen to people who think that they have all these resources available to them, but they still find themselves in these situations where they're terrified and don't seem to have access to the resources available.
And the shame is the shame.
The shame is the shame.
I think that so many victims don't want to tell their families and friends because they're so ashamed that they chose this person or that it's happened. And I went back to him, and I even knew it was like that, and then I went back again, and it's hard for them to say, okay, but happened in the past, those are my past decisions, but I have to move forward. That O.J. Simpson trial, it's an anniversary this year, so it's getting some press again. Some of her sisters have talked about what they had observed and how they had saw their sister just kind of shrink as a human. It's so sad.
Most of the time, people who work in domestic violence, they have a why. Can you share your why? How has this helped you in your position today?
Well, how I started is I started as a criminal prosecutor. That was my first legal position. And I prosecuted sex crimes cases and domestic violence cases. That is my why, because I had never been exposed to either. I had never had a friend or family member confide in me that they'd been a victim of a sexual assault or domestic violence. Looking back on it, I do have a few suspicions of people, but no one's ever, even those couple of people I'm thinking of, have never confided that in me. And I don't ask, it's not my business. As a prosecutor, I saw how many obstacles were in place for those victims. And when I decided to finish my career as a prosecutor after about 10 years, I knew that I still wanted to work with that population. So this was a way for me to still try to help people that are in that position and use my legal skills.
That had to have been very eye-opening. Completely understand why you wouldn't want to watch The Maids.
I was thinking the exact same thing.
Exactly. It really was eye-opening just to hear some of their stories. And, I would spend time talking to my witnesses, which were victims, and their family members. Or I had a case where it was in Kansas City, and I still even know the house. She rented a yellow house that she was so proud of with a couple of her friends. Her bedroom was on the first floor, and someone broke into her bedroom and raped her while her roommates were in the other rooms, but they didn't know because he had gagged her. Just listening to her story, and she immediately had to move out of that house, and she told her friends, hey, I don't think we're safe here. And I know that's not a domestic violence story, but it was so impactful. I didn't want to just practice law and not deal with important family issues.
What do you think's lacking in our legal system today?
Resources. We definitely need more law enforcement officers. I think Hope House does some great training with the law enforcement officers, but there's other training that they could get that they just probably don't have the resources for. I think that the courts need more resources. We do have in Jackson County Family Court Services, and they can do mediation free of charge or on a sliding scale depending on the party's financial status. But we need more of that, and we need to be able to offer more services. Free therapy. I know Hope House often has a wait for therapists. We definitely need more supervised visitation. We really mainly have 2 places here in Jackson County, and they are always understaffed. People aren't getting the supervised visitation, and that's important for the kids to keep those relationships going. Definitely could use more resources for programs like that.
What are you most proud of?
Every now and then, I'll have a former client, send me an email or leave a voicemail on my machine. It'll just be like, just thinking about you and thank you so much. Or I had a client actually after Christmas send me a really sweet email. We just finished a divorce, maybe October, and she said, I just want to say thank you so much to Hope House and to you. My kids and I had a really nice Christmas. It was one of the first Christmases where we didn't have any drama and any stress, and it was just so much fun. And just hearing those kind of thoughts that people are thriving, going on with their lives, and Hope House had a piece in it.
Well, you had a huge piece in that too. I mean, you truly are changing lives.
Yeah, sometimes. It takes a while though. Well, you just have to be persistent. Everyone else has to be persistent as well.
We were talking about resources and you're talking about law enforcement. Can you speak to the different law enforcement agencies that clients have an interaction with who Hope House has a really good working relationship with, and maybe law enforcement agency that they don't? Do you see different types of services being offered collaboratively to victims?
Well, Hope House has a very strong presence in eastern Jackson County. So Independence and Raytown and Lee Summit and Blue Springs, those police officers and the detectives, I mean, we know them by name, and we have advocates in their courts, and some of the advocates even go out as a first responder on scenes, and I know that that's just so impactful. The Kansas City, Missouri Police Department, Kansas City just inherently, it's obviously a very large city. It has a higher population. Maybe our relationships aren't as tight there, unfortunately. They have a lot of turnover, so, that's part of the process and part of the problem. But, for example, I have a case right now where a child went missing. She's 16, and for some reason, I think that made a difference to the Kansas City, Missouri Police Department, and I don't know why, because she's a child, but she went missing and was missing for 8 days. days. And my client is the father, and he pays for her cell phone. He owns her cell phone. It's his cell phone that he allows her to use. He pays for the service, and the police department refused to ping her phone. And he went back, and we had a temporary custody order that a judge had given him full sole legal and physical custody of that child. I gave him the certified copy. I said, go back to the police department, show him this, and say, she is my ward. She is my sole custody, and she is missing, and this is a dangerous situation, and I want her phone pinged. Her phone was turned off. He assumed that she turned it off, but we didn't know. And she did. The phone did do a few text messages to different people in that 8 days, but we don't know it was her texting. We know the phone number sent out a few texts. He hadn't heard her voice in 8 days, and they refused. They said, no, it's a search and seizure issue. So the guardian ad litem, who's an attorney, went to the police department with those documents and her legal documents and asked, and they refused. We went to the court, and the judge said, boy, I really think this should happen, but I'm not on the criminal docket, and I don't have the authority to issue a warrant. And plus, the police department has to ask for the warrant. It can't be the attorneys. So you would have to go through family court and see if the juvenile officer will ask for a warrant or if the Kansas City, Missouri Police Department will ask for a warrant. But you, as a guardian ad litem, or you, Nancy Putman, as an attorney, you don't even have the authority to ask for the warrant. And I honestly, as the judge, don't have the authority because I'm not on the criminal docket. So we just kept knocking our heads against the wall. That was disappointing. I wonder if we would have gotten the same answer from the Independence Police Department or the Raytown or Blue Springs or Early Summit. I wonder if they would have pinged that child's phone.
Was the child fine?
She's back.
Okay.
Probably not. She was gone for 8 days. The father did safely find her.
Thank goodness.
There's so many pieces to this. Hope House offers so much, but there's so many other pieces, with law enforcement and with the people as they're going through it and their own support systems. It's a hard problem to solve because there are so many moving pieces.
So many components to domestic violence. Nancy, I just want to thank you so much for coming on with Eileen and Marianne and I today. We value you so much in the work that you do here at Hope House.
Thank you. Thank you for having me.